doesn't reach that point because the judge has announced his intention to resign as from 5 p.m. on 5 November. Now, I would be deeply concerned myself as Speaker if my decision today hinged just on this timing issue. I would not wish to deprive members of the House debate on a serious issue just on the matter of timing. I think that would be a technical issue that would be somewhat unfortunate, although I don't want to breach the conventions in that regard. But still, I don't think that would be sufficient to turn down a debate at some point, at the appropriate point. But the greater concern is with respect to this House, just by way of an urgent debate, debating an issue of judicial conduct. I am troubled that would threaten seriously the proper relationship between this House and the judiciary. There is a proper way for matters with respect to the conduct of the judiciary to be brought before this House, because this House has a definite role in ensuring the accountability of our judiciary, our judicial system. But I think we would be wise to protect that proper procedure and process rather than put the proper separations of power under our Constitution at risk through seeking to depart from that traditional and process as laid out in the Constitution Act. That's why I've ruled that way.
Well, the Honourable Trevor Mallard, I don't see there's a lot more I can really...
Well, I think you have, Sir, gone to something which is important. I think most of us agree that getting this relationship right is important. I think, though, Sir, I'd ask you to reflect on some of the reasons underneath it, and that is this Parliament staying out of cases, especially cases which are live. But the other question I've got is to whether an opposition ever has a role in these matters, because as you're aware, the motion to which you refer is a motion that's moved by the attorney, and the question then is whether the opposition has any method at all of indicating dissatisfaction with the actions of the court, the running of the court, the Attorney General in his relationship, or her, in this case, her relationship with the courts. It is my opinion that the opposition should be allowed to criticise the Attorney General, the Minister of Justice, other people or the Minister for the Courts in relation to their running of the courts and their relationship with the judiciary. And so what I'm afraid is that your ruling might have taken us one step further away from the right of the opposition, which is very seldom used, but I think should be jealously guarded, to say to Attorneys General, either we agree with you, because most often we will, but also on that rare occasion that we think things have been handled badly, and people should have the right to say that, even if it does go close. Because, sir, in the end, other than those things by way of the Constitution Act, which is a way of sacking a judge, you do go to the Governor-General and ask for our rights for free expression. And, sir, it is my view that those rights to free expression do go to the right to criticise the administration of the court system.
Speaking further, I hear the Honourable Cherry Brownlee, but then I do want to move on.
Mr. Speaker, first I think you've outlined very well why this debate should not proceed. And the strongest point that I think you've touched on is that the Honourable Justice Wilson remains exactly that until the 5th of November. So if we were to engage in this debate at the moment, we would be talking about a person who is sitting on the Supreme Court, and therefore it would become inappropriate. When it comes to the actions of the Attorney General, those actions, of course, are open to question any day that the Parliament sits. And there is no restriction on asking questions about the activities of the Minister. Mr. Speaker, I think I don't want to stray into the territory of getting into the debate, But I would reiterate that while the person concerned sits on the Supreme Court bench, then it is appropriate for you to take the course of action that you have. Presumably, if there was some discomfort about that person sitting on the bench, then opposition parties are free to pursue the motion option by way of notice on the order paper of the House. And Mr. Mallard, the Honourable Trevor Mallard, is right to say that such a thing would be used very sparingly. But in the interim, a minister who has been involved in an activity is of course subject to question in this House without the, I would think, the prejudice that might fall upon the individual concerned in this case, should that be directed at him, as a debate of this nature would be.
I'll hear the Honourable David Parker finally.
One further point, sir. It would seem to me that if the judge concerned had gone through the full process, had been found to have erred, and then had been subject of a motion, that this matter would be discussed by the House. Can a judge avoid that scrutiny in Parliament in the face of those allegations by resigning? Because if that is the case, sir, then I would suggest that we should be able to debate these things in the face of resignation. Now, you might be right as to the timing, as to the 5th, but I would suggest that you reserve your position until the 5th in respect of the underlying issue.
I think I appreciate the honourable members' contributions. All have been, I've found, particularly helpful, because this is an important matter, and that's why I've been prepared to listen to points of order on the matter. And I appreciate the point raised by the Honourable Jerry Brownlee that this convention should not prevent a minister in making decisions from scrutiny around those decisions. And I think it was the Honourable Trevor Mallard has mentioned, well, hang on, what about a proper process for this House to address it, and especially the opposition perhaps, to raise issues of concern. And it may be a matter that the Standing Orders Committee could look at to contemplate further, because there has been most of the Speaker's rulings I refer to, of course, are very old. They go back to the turn of the century, basically. And there has been an issue of a notice of motion raised in this House, if I recollect correctly. But again, that was a long time ago, which shows the infrequency of these issues, which shows, I think, the respect this House does hold for the separations of power under our Constitution. But I think the members have all made a perfectly valid point. To me, as Speaker, what I would feel more comfortable with is a notice of motion procedure rather than simply an application for an urgent debate, although I do accept that is somewhat different from this situation, because a notice of motion procedure that wasn't initiated by the Attorney General, maybe it could arise where nothing was being done about a situation that a member of this House was very, very deeply concerned about. And so in terms of the transparency of the judiciary, I think there are mechanisms for this House to deal with them, either via the proper process via the Judicial Complaints Authority and a process of a panel and then the Attorney General putting a notice of motion into this House. There is that possibility of a notice of motion being raised in the House, but I don't think an urgent debate is the way to deal with these issues, and that's why I've raised this, because I don't want my decision to turn purely on the date of resignation, because I don't think that would be very appropriate. I think there are deeper issues here, and the fact a judge is resigning on the 5th of November means that issue is being dealt with. The issues involving the minister, she's open to scrutiny on those as minister. So I think those issues, as the Leader of the House has pointed out, can be dealt with. So I remain comfortable with my ruling today, but I accept it's an important issue. I don't want to deny the rights of this House to, on the rare occasion, to address these issues, but I believe proper procedures should be followed for doing that, and I don't believe an urgent debate is the proper procedure for doing that.
One final point of order, sir, and it doesn't relate to this ruling, but it does go to now that this matter has been dealt with, and I presume the delegation is now will within days be finished, because it was to deal with this matter